Hey, what's up, everyone? It's Steve from Chamberlains law firm, and today we're going to be chatting about asset protection and trust. And it's a pretty exciting topic. This is the first time I've gone live on any of the firm's social media feeds. So, hi, Emma Brown. Nice to see you. Thanks for tuning in. Look, pretty excited. I've got traditional notes with me. So if you see me popping down and having a look, it's because I'm a little bit computer illiterate, but let's get started. Today, we're going to be talking first about the basics of trusts and then generally engaging with a bunch of issues around the intersection of the drafting and preparation of trusts, the administration of trusts, asset protection, as well as how all of those planning endeavours and our interactions as advisors work with respect to bankruptcy and family law. So let's get right into it. So what are the types of trusts? And there's so many. There's so many different types of trusts that people run into as part of their day-to-day, both as clients of lawyers, people in business, and those just undertaking their affairs on a day-to-day basis. But we're going to be talking about two particular types of written trusts, and those are inter vivos trusts and testamentary trusts, and particularly trusts of both of those types that are distilled down into writing and have a discretionary element. So talking through those in a bit more detail, an inter vivos trust really became popular in England about 120 years ago when they introduced death taxes to penalise the aristocracy for being rich. And they introduced inter vivos trust to allow people to settle trusts and have the assets be preserved past the lifetime of their settlors. And then testamentary trusts are trusts which are created upon someone's passing in a testamentary instrument such as a will. And on their own, trusts like this are not particularly helpful for asset protection. So when we talk about accountants or other advisors, financial planners, talking about trusts, they might refer to these types of trusts and not be sure of why they're good for asset protection. But the reason they are good for asset protection is because they can be drafted in a way that has a discretionary component. And what I mean by that is a discretionary relationship between the party that owns and administers the trust assets and parties that claim entitlement to the trust assets. So in that respect, we start thinking about, well, what are the roles of people and parties involved in trusts? And so you've got the trustor. The trustor is the person, usually, the wealthy individual back in the day who has the big country estate, and they want to settle or bequeath those assets into a trust for the benefit of other people. And so in an inter vivos trust, that person would be the settlor, and they would do that whilst they're alive. Whereas in a testamentary trust, the person would be the trustor, and that would be the testator, the person who's prepared the will. So effectively, that would be the assets that they bequest into the trust as part of their will. Then we've got the appointor. So the appointor is a party that ultimately wields the power to actually decide who the trustee will be. And then the trustee is the person who owns has the legal ownership of the assets rather than the equitable entitlement to the assets. So the trustee is commonly the party that would be described as owning the assets of a trust as trustee for the trust. And a trust is really an amorphous instrument, in this case established in writing, which is there to provide a certain relationship, in this case a discretionary relationship, between beneficiaries and the trustee. And so this is where we start getting into, well, who are the beneficiaries? What are their rights? In the context of discretionary trusts, beneficiaries are merely parties who have an interest in the proper administration of the trust by the trustee and who have their rights protected by the appointor. But they don't have a specific exhaustive right to any of the capital or the income from the trust. And so the reason why I say that as an absolute statement is it's actually the bastardization of this very simple concept, which has seen the asset protection afforded by trusts effectively diminished over the years. So I would say if you're an advisor or an individual engaged in asset protection planning, make sure you speak to a lawyer, because it's actually the maladministration of this discretionary component which has eroded the asset protection elements of it. And that's a big deal, because, you know, what is the point of otherwise establishing these mechanisms if not for asset protection? So what are the advantages of trust? Well, there's heaps of advantages. There's also lots of disadvantages. I mean, some of the disadvantages are they're more expensive to administer than ordinary legal affairs because they require separate administration and accounting and compliance costs, but they can provide certain benefits, including asset protection. And also, if you're thinking about testamentary discretionary trusts, they're still afforded, as the date of this discussion, some limited tax effectiveness as well. So if you've got minor beneficiaries drawing income from a testamentary discretionary trust, they actually get benefit of the full tax-free threshold rather than a significantly reduced tax-free threshold for ordinary inter vivos discretionary trusts. So that's one that accountants know and commonly talk to their clients about. But a lot of estate planning lawyers, for example, don't necessarily discuss in adequate detail. So that's one for the financial planners as well. And if we're talking about asset protection, what is asset protection? And I would say, well, in the context of asset protection, there is the strategy of the porcupine. So we make ourselves visible but spiky and difficult to get at. Or alternatively, we make ourselves hidden. So the wombat, we burrow underground and we hide from people and hide our assets in that way. And trust can achieve asset protection in both of those ways. And as advisors, trusts are useful in protecting beneficiaries' inability to manage assets due to their own youth, immaturity, disability, for example, or even in some cases bankruptcy or poor financial management. And they can also protect them from themselves, poor life choices with respect to partners, divorce, etc. So there are lots of benefits. It's just about using the tools at our disposal in the right way. So getting into, I guess, some interesting points around the scope of the asset protection of trust, there are a lot of misconceptions. So I just want to throw out my views on those misconceptions, because it's missold, particularly by accountants, to their clients. Firstly, trusts do not provide an infinite or absolute asset protection advantage. Two, the drafting of a trust is very important. So using an off-the-rack automated trust form from ClearDocs or someone like that can provide you with some benefits, but it's not necessarily the gold standard. So if we're talking about special roles of individuals within the trust relationship, if you were thinking about a particularly at-risk beneficiary, you might actually consider drafting in a special role called a protector. So someone whose job it is to actually review the conduct of the appointer and the trustee to make sure that they're not maladministering the trust, either for financial reasons or for some asset protection reason. Because as you'll see when I get into the bankruptcy and family law cases, it's very easy to get it wrong. It's very easy to get it wrong. So in reality, the level of protection from a trust is limited, and it depends on the applicable law. It depends on how you administer the trust. It depends on the particular terms of the trust. That's a really big one. And it also depends on the physical division of roles and power and labor in the trust. So having all these different roles, but then having a single person or a select handful of people or a group of people acting in cahoots, and I love the word cahoots, with each other is not really effective as well. And you'll see that when we get to the cases. An ostrich. I must say, trusts don't really help you run away from things very quickly. They are complicated and difficult to deal with. So I think, Mr. Hugh David, if you're going to be using the ostrich approach, you probably consider an instrument that isn't a trust. So in the context of bankruptcy, there are two fundamental ways in which assets can actually come under attack. And I say attack in, I guess a loose colloquial way, because as advisors who commonly advise bankruptcy trustees, we wouldn't necessarily consider it to be attack. We'd almost say, well, a necessary part of the obligations of a trustee in administering their day-to-day affairs in administering bankrupt estates. But those assets can be attacked by becoming the divisible property of a bankrupt estate, or they can otherwise be attacked by a bankruptcy trustee under the voidance provisions. So these are certain provisions under the Bankruptcy Act which allow a bankruptcy trustee to investigate and attack certain transactions for being adverse to the goals of the Bankruptcy Act and adverse to the needs of creditors. So those things might be things like transfers for below marketable value, unfair preferences, and transfers to defeat creditors, as well as some certain special powers, which we'll talk about in a bit more detail. So getting into divisible property and asset protection, we're really talking about what is the divisible property of a beneficiary, because ultimately trusts are there to establish relationships between set laws via trustees with beneficiaries, and beneficiaries are normally the party we're there to try to protect. So if a beneficiary is facing an imminent risk of bankruptcy, we need to consider what will actually form part of their bankrupt estate. So Section 116 of the Bankruptcy Act actually defines an exhaustive list of all of the property that becomes part of the bankrupt estate. And it's commonly pretty easy for someone to say, well, all of your property becomes property of the bankrupt estate, but that's not really true. So what is divisible? Divisible just means, is it an asset which the Bankruptcy Act says will vest legally in the bankruptcy trustee? So is it an asset which the Bankruptcy Act says the bankruptcy trustee can take and sell and then divide amongst your creditors? So in that respect, all of your ordinary property rights, real property, personal property, most of your choses in action, any benefits accrued from personal services. So if you're an Instagram personality or an actor, or you derive value from your personal image or personal services you provide, adult workers, etc., it's very, very difficult to avoid the benefits derived from that actually being part of, I guess, an asset protection mechanism, because it's likely that all of those personal services become divisible property. So the question then becomes, what is divisible property, and in what circumstances will rights that you have under a trust, or in this case a discretionary trust, whether it's testamentary or inter vivos, in what circumstances will the court say, hey, that's actually property that is divisible amongst your creditors in bankruptcy? So there's a bunch of cases, and the simple answer is 50 years ago in 1968, there's a well-known case called Gartside, and it was pretty easy back then. If we were around in the 1960s, but for the technological limitations, we wouldn't even be talking about this right now. It'd be as simple as saying there's a discretionary relationship between beneficiaries and trustees. The beneficiaries only have a discretionary right to rely on the potential administration of a trust in their favor, and no exhaustive right to capital or income, and we left it at that. And that's where I think a lot of accountants and financial planners think it ends. But unfortunately, the last 50 years have seen a massive erosion of protections afforded by trusts, and particularly discretionary trusts. So we're going to get into it now. In 2006, we can blame OneTel, we can blame Jody Rich, but he wrecked it for everyone. In 2006, the general principle is what I said. And all of a sudden, we started getting this discourse around the alter ego. And so the question started to become, well, if a trust is an alter ego around the trustee or the beneficiary, or a combination of the two, then maybe the trust isn't real. Or even if the trust is real, maybe creditors in the context of a bankrupt estate or in the context of other unsecured claims might actually start having rights which far and exceed the historic rights of beneficiaries to just be entitled to a distribution of income or capital from time to time. And it's quite scary and unfortunate in a way, because Justice French, who was involved in that decision in the Rich case in 2006, then went on to eventually be Chief Justice of the High Court as well, and continued, I guess, that line of reasoning. And you can see the ongoing erosion of the asset protection afforded by trusts has continued as that particular judicial officer has proceeded in their career and proceeded to hear more decisions in this area. And I guess arising out of this are three scenarios these days where under bankruptcy, there is actually a very clear erosion of the asset protection afforded by trusts when beneficiaries or trustees or both go into bankruptcy. And those are where the defendant is both the beneficiary as well as the director and secretary of the corporate trustee. And we see this all the time. I mean, that's not uncommon. There's a second scenario where the defendant is a trustee and beneficiary and has discretion over 39% of income or capital to a targeted beneficiary. So this one's pretty scary as well when you think about it, because a lot of exhaustive style trusts, or in many respects hybrid trusts that people prepare for property development purposes and certain special joint ventures and projects in certain industries, tend to have an exhaustive element. And that's really scary when you're talking about it in the context of asset protection, because that's that second limb of that decision by Justice French, where they have a fixed exhaustive right to a particular distribution and control over how a beneficiary will have that exhaustive right exercised. So in a way, it's not purely discretionary anymore, is it? And then obviously the third category is where the defendant, so being the bankrupt in this case, is the beneficiary and the appointor of the trust. So again, really scary. If you're talking about all the circumstances in which I've even personally seen a scenario where a bankrupt beneficiary is also the appointor of a trust, it's like very common, very common. So you start to see that regardless of the law, regardless of the way you draft the trust deed, it's not just about that. It's about the actual administration of the trust and the physical distribution of labour and roles within that, not just the preparation of those roles. And so by 2008, there started to be an elaborate case law around what is really the erosion of asset protection afforded by trusts. And so it's important to note that not every case since 2008 has been a blanket, no, you've got a trust, and in those circumstances, you're not afforded any asset protection. So I just wanted to talk about one where there was actually some asset protection afforded by a trust, and this is a well-known case in the New South Wales Supreme Court called the Public Trustee in Smith. It involved the disposition of real property by will, so it really relates more to testamentary discretionary trusts. And it was a issue where the real property was owned by the trustee, the discretionary trust. The deceased was a beneficiary of the trust. The deceased was the appointor of the trust, and the deceased owned all of the shares in the trustee and was not its sole director. However, in that particular instance, the court decided to actually disagree and dissent from the prevailing course of case law arising out of the Rich Star case and the Jody Rich decision. So this is not settled law. I'm not saying that you should just rip up your trust deed and go with another asset protection strategy. All I'm saying is that it's uncertain, and it's really about just making sure that you're thinking about the administration of the trust in a way that is more than just superficial and more than just jumping online, downloading an automated trust deed and putting it in the drawer. It's a living thing that you need to engage with all of the time. Separately, I guess there's a couple of other things that come up in bankruptcy that are related to the rights of bankruptcy trustees to actually attack trust assets, or at least the interests of beneficiaries. And so Section 302B of the Bankruptcy Act, it's all the way down the bottom. A lot of people, including bankruptcy lawyers, don't even know that it exists, and it's pretty funny when you tell people about it. So this one I'd absolutely write down if I were you. basically, the Bankruptcy Act specifically voids an entire trust deed. So not just the section of the trust deed that deals with this issue, that seeks to cancel, reduce, or qualify a beneficiary's interest in a trust, or allows a trustee to exercise discretion to the detriment of the beneficiary due to the beneficiary committing an act of bankruptcy. So that's particularly scary because this is not an uncommon strategy which a lot of estate planning lawyers use when they start engaging in planning around protecting potentially at-risk beneficiaries under testamentary discretionary trust, and that's because they're not engaging in the bankruptcy regime very often. So if you do this, your trust deed will be void, and I welcome all of you to jump on Coffee and a Case Note and have a chat to our trust guys to get a feel for what actually happens when your trust deed is void, because it's really messy. It's just really bad. So I don't want to harp on about that for too long. And then I guess you've got that final layer of complexity in the context of trust, which is sections 120, 121, 122 of the Bankruptcy Act, the avoidance provisions. So if you make dispositions at a time when you're financially distressed, so think about a hypothetical scenario where, you know, my hypothetically wealthy grandfather has decided Stip's an at-risk individual and is going to set up a testamentary discretionary trust. Well, that's fine. But what if in circumstances prior to the establishment of that trust, he's done certain things which are otherwise voidable under the Bankruptcy Act, and his deceased estate becomes bankrupt under Part 11 of the Bankruptcy Act? I mean, so few people engage with Part 11 of the Bankruptcy Act. It's not funny. It's actually depressing how little people know about it. So even this simple hypothetical scenario would be really challenging for someone to deal with. Oh, I've got a question. What would a liquidator of a company do, and would they have similar powers? So yes, a liquidator of a company does have similar powers to attack voidable transactions prior to the disposition of an asset into a trust. So that's very different to attacking the assets of a bankrupt beneficiary under a trust. So this is maybe a company which owns assets, which would then dispose of those assets into a trust, and then try to rely on those assets being owned by the trust to, you know, I guess, have some superficial level of asset protection. But again, if we're talking about the wombat versus the porcupine, it's a porcupine approach, not a wombat, because there would be proof of those assets being transferred. And though the porcupine might be prickly, not to stretch an analogy, they would have a very clear right to actually attack those assets under most of Part 5.B of the Corporations Act for voidable transactions. So, I mean, you can see there that just in the context of bankruptcy, it's not easy, it's not straightforward, it's not as clear cut as people think it is, and you should be getting legal advice before you set up your trust and as you administer your trust. So moving on to the pretty scary area of family law, though. And I'm not a family lawyer, so if I get something wrong, yell at me, jump online, leave some comments. We've got a great family law team. I can see Gillian's online giving me a wave. Hi, Gillian. It's pretty scary, because if you think that in the context of bankruptcy, there are so many important factors to consider: the growing definition of property under the Bankruptcy Act, the need to separate the roles of appointor and protector and trustee and beneficiary, and then other issues regarding the administration. Well, family law is just scary. I mean, family law is what I call the shaker fries test. So under family law, trusts, though they retain a legal character, and the family law regime is federal outside of WA, of course, in nature, the way that it interacts with state laws with respect to trust is not clear, and it's not settled. And I'll try to breeze through the beginning parts of this discussion, because there's a particular case I want to get to a bit later about how messy it is and how much you want to just avoid trying to rely on a superficial trust structure in minimizing your exposure in family law proceedings. And it's something people really need to consider when they're doing planning, and also why it's important to, as you're setting up trust structures, also consider binding financial agreements and things like that, other types of things you can do in the family law regime to support your personal and private wealth asset protection strategies. So Under the family law regime, there's basically 5 ways that the family court can effectively bust a trust. So, I mean, I like to use trust busting as the phrase for the family law regime, and those are firstly to treat trust assets as property of the parties to a marriage, and that's pretty scary just thinking about it. The second one is to treat trust assets as a financial resource for a party to the marriage. The third one is to set aside transactions generally under the broad powers of Section 106B of the Family Law Act and a number of other sections. It's pretty broad. It's scary, again. To alter the ownership of property of a third party under the Family Law Act, and to generally to treat the trust as a share. And so all of these, other than the first two, can be sort of done concurrently as part of the court's general power to deal with assets. And the considerations that the court makes when they're thinking about exercising these various powers are inherent to the family law jurisdiction. They're sadly and commonly inconsistent. There's like very inconsistent with trust law from a common law perspective, and wholly inconsistent with the assessments applied in the bankruptcy regime, even though they use very similar wording. So getting into, I guess, the 4-step process for dealing with those first two issues, so treating trust assets as property or alternatively treating trust assets as a financial resource. I'll go through the 4-step process. Obviously, this is a insolvency lawyer's assessment of the process. It's not going to be as nuanced as a family lawyer's view, but they identify all the value of the properties and liabilities and basically everything that's available to the parties, including financial resources. They then identify and assess contributions of the parties and determine contribution-based entitlements. They then have a look at future needs factors, which if you're talking about commercial lawyers such as myself, we have no idea what that means. So speak to a family lawyer about it. It sounds pretty scary. And then they consider the effects of these findings and resolve what is just and equitable. So they basically just put it in a bag and they shake it up and you got shaker fries at the end. And so it's pretty scary. If you're sat there and you've advised the client an asset protection strategy and it's all getting put into, you know, the proverbial mix of family law investigations and interrogations, you just don't always know what's going to happen. So getting into, I guess, an interesting point around the identification of financial resources. So this is something that is done early on in family court matters. And I know that they're amorphous and so many interlocutory issues come up throughout a family court case. But if you're talking about a last opportunity for your client to get good asset protection advice, even if it's just from a litigation strategy perspective, it's right then. Once they start talking to their family lawyer about financial resources, they should be talking about how that trust should be treated. So this is commonly, at least in my limited experience, defined or at least explained by a lot of clients about, well, look, you know, I'm comfortable with, you know, the family court dealing with our personal assets in a particular way, but I want to preserve my interest in my business assets, or I want to preserve my interest in my testamentary discretionary trust interest, which I received from granddad before or as he passed away. And so it's really important to make sure that if a client wants to preserve those and not have the court make an order physically dividing those assets, regardless of them being in a trust or not, they need to be deemed a financial resource, not just property that is available for distribution. And then that will impact the capacity of the court to then make apportionments of the remaining assets. So that's a pretty important thing to consider. Moving down the list of other things that people really need to consider as far as asset protection, trusts, and family law, we get into Section 106B, and that's where we start to think about actions taken by parties to actually avoid current or anticipated orders of the court, or just the impact of proceedings. And this is where the court gets to exercise all those other powers about treating the trust as a sham, dealing with the rights of third parties, looking through the legal structures and making directions. And when the court makes these directions, it makes these directions regardless of a consideration for a specific other legal need. And it's important to note as well that not all actions that courts take will have exemptions under state laws or even federal laws for the purpose of family law restructuring. So some of the well-known cases that I'll mention a bit later actually result in perverse outcomes where there might be adverse taxation consequences for the trust. There might be adverse consequences for breaches of other fiduciary duties as a result of the directions of the family court, because the state legislation doesn't necessarily have everything drafted in a way that is consistent with the very broad powers of the family courts under this particular regime. And that's without even saying how sort of, I guess I keep saying the word scary, family law is scary, but the generally broad power of the family court in this particular instance has often been deemed unconstitutional by commercial insolvency lawyers such as myself. I'm not going to foray into constitutional law, but it's very broad and it can result in many adverse consequences. So looking at, I guess, a very well-known case, this is a case where I'm going to summarize the facts because it probably requires a flowchart. But it's a case where there was a husband and wife, and the husband and wife found the scenario where the husband was effectively acting as the alter ego, with respect to a trust. And what the court ultimately found was that the trust was the alter ego of the husband and ordered the husband to appoint himself as trustee and pay a lump sum to the wife. Now, that sounds pretty germane, but really it's quite scary when you think about it in the context of the family court being able to reach through a trust instrument, reach through a state law, and decide who will be the trustee and what that trustee will do. And you can imagine that if there was some conjecture about the independent rights and obligations of those parties, it is a great source of great conflict. Absolutely. I mean, this is a really interesting comment on Facebook here, and I think it goes to say the case I'm talking about is one where the very orders of the court actually created conflict for the parties, and ultimately they found that in this particular case that the husband's right of appointment on its own and the administration of the trust throughout the course of its life was actually proof that it was the alter ego of the husband, and it just stepped through and it just made a decision. And so that's pretty scary. So that was the case of Ashton. And so we get into another really interesting case called the case of Davidson. And this was a case where a husband owned and controlled a trustee company, which was a trustee of a discretionary family trust. And the husband was the sole appointor, but not beneficiary. And the wife and grandchildren were beneficiaries who, when they received distributions, would loan or give the money to the husband. And so you can see, even in the context of the bankruptcy analysis we did a bit earlier, and now some of the discussion we've had around family law, we can see that it's likely that a case like this would have those reach through powers exercised, and there would be some real concerns in and around, well, ultimately the independence of the trust, the independence of the trustee, the administration of the trust, all of those things that we mentioned. And in this case, the case ran for 4 years. And the reason why this case is scary is because, not just because of the outcome, but because of the procedural effects and its interaction with state law. So to give you an example, there was a trial hearing in the family court. I'm going to refer to my notes. Then there was a stay of enforcement application in the state jurisdictions. Then there was an appeal. Then there was an application for special leave to the High Court. Then there was another enforcement hearing in the relevant state jurisdiction. Then there was an appealed enforcement order. Then there were separate proceedings in the state jurisdiction. Then there was an appeal. And eventually everything came crumbling down and the alter ego finding was found. So the reason I raise this is because, again, the trust on its own is not enough, and you shouldn't just be relying on some technical document to try to exert some overly broad asset protection strategy. It's part of a bundle of strategies, including the administration of the trust, the context of family law proceedings, the context of bankruptcy proceedings, which we need to consider. And that's when we get into, I guess, the really well-known considerations under, I'm just having some issues. Well-known case of Kennan and Spry, and this is one that has been mentioned by a few of our viewers today. And this is, I guess, the case which brought it all together with respect to the alter ego and the family court. And it's actually a case that I really like because it's got a really well-known dissent from Justice Hayden, which is really the basis for criticising all of the family court's analysis and judgments in this area. And what I can say is if you've got a poorly administered discretionary trust, whether it's a testamentary trust or an inter vivos trust, and you're in the family court, you're probably in trouble. And that's where it ends. But if you want to have a good read, have a read of the dissenting decision of Justice Hayden, because it is basically the reason why commercial lawyers and family lawyers disagree about this issue. So I guess tying it all together, asset protection, trusts, bankruptcy, family law, the steps. Do a great fact find. Make sure you engage with your client and their other advisors, their financial advisors in particular, about not just their current financial position and not just their long-term goals, not just their goals around what they want to achieve from a financial perspective, not just their goals from an asset protection perspective, but also their habits and the habits of the individuals they want to protect. And draft and build processes, asset protection processes, trust documents, procedures that work to the habits and goals of the at-risk beneficiaries. If you've got a beneficiary who you know is in construction, and 35% of construction companies go into insolvency, and you know that they're a higher risk for a bankruptcy scenario arising out of a business default, then you're going to prepare an asset protection strategy which is tailored and a trust which is tailored to that particular type of risk. If you've got someone who is in a relatively low risk environment and might otherwise inherit or get the benefit of some trust, but they are unlucky in love, then you need to consider the family law elements, and you need to consider the true independence of a third party administering a trust. I take private trustee appointments not uncommonly for this reason alone, because it's a lot harder for a family court to turn around and say there's an alter ego when a genuine third party administers the affairs of a trust for the benefit of a beneficiary in a non-exhaustive way, in a way that's consistent with their other goals and inconsistent with an order that the courts commonly find in the family court. So all of these things you need to consider, and once you've considered those things, then get down to drafting the trust deed and drafting it custom for every client, and considering whether you even need special needs, special appointments such as the protector, whether you need other structures or even completely different structures. A trust might not be the right way to go about it. Start considering traditional tools around joint tenancy with other people in the family. This is an interesting way to transfer assets in the context of someone being deceased. Consider the use of superannuation. Consider the use of, I guess, to put it very openly in a public forum, even the use of the legal and timely disposal of assets outside of jurisdiction. That's something which is completely appropriate in certain circumstances and wholly inappropriate in other circumstances, but something which you should consider if you're going to be providing holistic advice to your clients about, what could happen over the course of not just their own life, but the life of a trust and multiple lives if you're talking about a testamentary discretionary trust. So look, it's been awesome to chat with everyone and present this CPD, and I'm looking forward to catching up with people really soon. Peace.